Okay, thank you. Good morning, everyone, and welcome to the last day of the Punishment in Global Peripheries workshop series. I am Naida from the Center for Criminology at the University of Oxford, and I'll be chairing this session. So today in this session, we have two presenters and then one discussant. And we have Professor Vijay from Tata Institute of Social Sciences in Mumbai. And then we have Ariel, a PhD student at the Monash University in Australia. And then our discussant will be Professor Dirk from the University of Nottingham. I want to kindly remind everyone to keep their microphones off, and then you'll be given the chance to ask your questions after the discussant is done giving his comments during the Q&A session. And then if you want to ask a question during the Q&A, you have to raise your hands virtually using the Zoom tool. And then don't worry about the Q&A, it won't be recorded. And for now, the session is being recorded. So if you don't want to come live, you can put off your camera. So now we start with Ariel. Yeah, thank you.
All right, hi everyone. I'm just going to share my screen. Can everyone see that? All good? Okay. All right, so thank you for being here today, and thank you for the introduction. So as you can tell from the slides, my name is Ariel, and I'm from Monash University. I have to say that I'm very much enjoying this workshop and being able to learn and engage with scholars across different states and time zones from the comfort of my own home, thanks to the pandemic. But in all seriousness, thank you, Louise and Maximo, and everyone else who's working behind the scenes for your efforts in organizing this. So before I begin my presentation, I would like to acknowledge that I am able to conduct my research and complete my thesis as I live and work on Aboriginal land. I wish to acknowledge the Wadawurrung people as the traditional owners of this land that was never ceded. I would also like to pay my respects to their elders past and present, and Aboriginal elders or any other First Nations people from other communities who may be here today. I would also like to acknowledge my research participants, survivors of political detention and violence. I would like to thank these brave men and women who took the time to sit down with me to speak truths and share their experiences. This research would not exist if not for your time and effort. Thank you. So my research is about the lived experiences of indefinite detention without trial. In my doctoral research, I examined experiences in Singapore from 1948 to 2000. So as listed here, detention was enabled under legislation highlighted in red, while accompanying legislation enacted before 1965 allowed for the detention, which was often followed by deportation, forced relocation, or banishment. Although I focus on detention experiences in my thesis, these listed powers enable detention, deportation, and banishment without trial or criminal charge. The practice of indefinite detention without trial continues under the Internal Security Act as the Singapore government continues to use temporary emergency legislation to counter suspected terrorist-related activity in Singapore. I focus on experiences prior to 9/11. This is because temporary emergency powers enacted by the British colonial government of Malaya in 1948 enabled for political detention of over 2,460 individuals in Singapore from 1959 to 1990 alone. I affirm previous survivors' statements and records from historical research, who state that these numbers are underestimated by at least 65%. It is evident that state-reported numbers do not reflect the number of detainees accurately. My findings indicate that these estimates might at least be 3 to 4 times the amount published by the state. As participants reiterated repeated catch and release experiences, this was experienced before detention and after detention as well. So as you can see from the slide, and you can tell from Sokchin's quote here, Participants discussed the process and nature of state rearrest or repeated catch and release experiences. Just last year, historians found that at least 650,000 Chinese migrants were detained and relocated from 1948 to 1960 alone, indicating that temporary emergency powers enacted by the British allowed for indefinite detention of about 1 in 10 persons in Malaya during this time. So fast forward to last year, COVID-19 has seen to increase surveillance technology and administrative power that has enabled state access of information from Singaporeans residents' mobile devices, so Bluetooth technology, tracking data, what have you. This allowed for increased police intervention and for the recent detention of a 16-year-old, so 1-6, under the Internal Security Act in January this year. He remains in detention for being suspected of planning anti-Muslim activity. The Internal Security Department reported in April this year that, I quote, it has dealt with 54 individuals since 2015 in relation to online radicalization alone. So all this evidence, these numbers, pre and without trial detention, increased surveillance, increased legislative and administrative powers, amplified policing, the detention of minors. This all highlights why we should care about atrocities conducted in Singapore, both as an independent state and as part of Malaya as well. Not only because detention without trial found its roots in the Malayan emergency, but also because police powers and accompanying administrative and legislative rationale continues to be used by the Singapore government today. I would like to note for the theoretical buffs out there, before I just briefly skim through my methods so I can focus on the findings, that harm is conceived as a multi-layered continuum that includes the hurt, pain, suffering associated with participants' contact with the detention chain. I rely on Niels Christie's definition that the state manufactures and routinizes the infliction of pain, that is punishment, or in this case, detention. And in chapter 4, for example, of my thesis, police powers include surveillance, routine questioning, which is essentially police interrogation, police custody, police raid, documentation and personal belongings seizure, so passports, identity documents, visa documents. They were seized and they were all intended to hurt. Christie's definition allows me to understand how these punishments hurt, how policing, detention, torture, forced confession, and quote unquote rehabilitation, which is often referred to as brainwashing by the survivors, and reintegration, so how these punishments hurt, how it feels, the suffering and the sorrow. Before I move on to talk about my findings and the main themes, I would like to elaborate on the second point. So my participants, this includes a significant amount, so about slightly over 30% of my participants now reside overseas on a permanent basis due to deportation, banishment, and forced migration that I elaborated on previously. And many of them are unable to return to Singapore to see their loved ones. So another form of punishment for us to think about as well. So with regards to the first point, what do I mean by extending notions of policing, punishment, and rehabilitation? Following Hannah Moffat and Lynch's emphasis in 2012, expanding our, and I quote, our understanding of what counts as punishment, quote, taken for granted boundaries of punishment in order to, and I quote, disrupt traditional frames of understanding within criminal law, criminology, punishment, prison, and the nation state. So this was written by Katja Franco-Ars in 2013 as well. So the case of political detention in Singapore allows us to understand how all these instruments of pain relate to each other and how this informs collective memory and trauma in widely publicized and oft-politically extolled spectacle of punishment, which is accomplished through overreactive policing and punishment in Singapore that exists outside and beyond the traditional bounds of the criminal justice system. That is, as we understand the criminal justice system within Western and Anglophone contexts. So policing and punishment was and remains painful and punitive in Singapore. Punishment of thought in this instance, or deferring, counter, critical, or contradictory to state preferred behavior, through policing extends all the way from surveillance. So at the point where participants realize they are being watched or followed, up to the point of routine questioning, which is essentially police interrogation, so not as innocent as it sounds. Police raids, long-term police custody, including solitary confinement in some instances. So all this happened before official capture, before evidence was produced. So capture is the term I use for political arrests because I would like to shift narratives away from state assertions of guilt and criminality and prioritize survivor truths. So finally, rehabilitation. So rehabilitation includes what survivors describe as brainwashing. So that's why I put it in inverted commas, because they were coerced into signing statements of forced confession. Although some of them resisted all the way and they did not sign any of these. Most of them did sign forced confession because they were coerced through a lot of physical and psychological torture. So they were also coerced into verbal denouncement of political, trade, union, or even religious affiliation, to name a few, for example. After periods of prolonged solitary confinement, so physical and psychological torture. And what is significant is psychological torture included threats and harassments directed at their family members as well. So this leads me to the second and the third points. So I would like to focus on the third point because the second can be inferred more directly from the earlier discussion in the second slide, when I emphasized about British colonial inheritance and the emergency mindset. So the legacy of this emergency mindset confirms Mark Brown's assertion on, and I quote, the long shadow of colonialism. So this ties in with the third point. So with regards to traumatic legacy, and family members as victim survivors of state political violence, not only because they themselves were often arrested as well, pulled out repeatedly for routine questioning, subject to home raids, but also they were also deported, banished, and banned from re-entering, studying in, or working in Singapore, effectively punishing and inflicting hurt and suffering through social, movement, and financial deprivation of family members. So notwithstanding all these administrative punishment, the detention of both parents, for example, or just one parent, so the single sole breadwinner of respective families, which is quite common during that historical period, this inflicted significant hurt and suffering in itself, which resulted in self-harm and suicide of detainees' parents and or spouse in several instances, notwithstanding suicide in detention resulting from torture and forced confession that occurred as well. So ultimately leading us to start to understand, or if you will, untangle the many harms resulting from this complex web of punishment through intersecting chains of detention, demonstrating the structural nature of state violence. As listed on the slide, these traumatic detention consequences interacted. So bring your attention to point number 4. And they continue to interact to result in social, physical, and psychological, as well as emotional detriment, having significant impact on survivors and their families' life course, their jobs, and their living situation, their quality of life, which is, of course, tied in with health and well-being. So this is an outline of my findings chapter. And I won't elaborate on the blue one, which is chapter 4, because I touched quite a bit on this so far, and I also submitted it in my paper. So the main research themes, I think they lay evidently in the conceptions of pain. So how this affects a response on survivors' self, similar to what Mary Bosworth and Goffman conceived on identity, but perhaps a more culturally and contextually relevant interpretation to indefinite detention in Singapore, and in relation to culture in Southeast Asia as well. So linguistically and collectively informed notions of the self. And by self, I mean, this is translated from like various respective native Chinese, Malay, and Indian dialect, which translates in English language to self, person, or being, which includes definitions of self-worth, self-respect, dignity, social standing, status, honor, pride, face. So these three: honor, pride, face, and identity as well, in relation to social belonging to respective organizations, as well as identity in being Malayan and being Singaporean, for example. So while we think about that, as we shift our attention back to pains in relation to physical and psychological assaults conducted on the self throughout detention or the detention chain, pains are also conceived in a multi-layered mode. So pains are physical, they're psychological, emotional, intersecting, cumulative, and traumatic. The important thing that I seek to do in chapters 6 and 7, so in red and green here, is to understand and analyze how survivors sought to rebuild, resist, and cope with state-asserted guilt, which was often met with more force and violence. So as you can see in red, they were often subject to more torture when they resisted and conducted hunger strike, for example, because this resulted in more torture and more force feeding through tubes. So all this in addition to forced confession, following a series of assaults that sought to degrade, demean, humiliate, and dehumanize detainees. These assaults were not just physically violent in nature, because I recorded over 20 modes of torture that were physically violent, but importantly, they inflicted immense amount of psychological hurt and suffering through embedded everyday rituals, which is a little bit similar to what Andrew and Thomas discussed in the second session on Ponzan. I might be mispronouncing that. So, but what is different is in this instance, it's clothing, garb, assignment, and numerical roll call, which are embedded in the everyday rituals that degrade and dehumanize. So this was experienced in addition to torture and the threat and harassment of and arrest of the family members as well. So another significant finding was how frequently solitary confinement was used. By the time of their release, most of the survivors that I interviewed experienced at least 3 instances of solitary confinement. They typically range from 10 to 14 days, but I recorded 28 accounts, so over 40% of them, where solitary confinement was experienced for at least over a month each time, and up to 2 cases of solitary confinement that was experienced just short of 7 months in the longest instance. So all these pains and suffering led to hunger strike, as I will discuss in my 6th chapter in red. And I just want to elaborate on the last point on the degradation. So degradation and dehumanization embedded throughout the detention process, of course, but it's important to think about how state denial, which continues, and refutal and political rebuttals of historical accounts of survivor truths, and action to ban, police, and control documentaries, for example, or any other educational awareness that is being raised on this issue. This needs to be conceived as further degradation that adds to the continuing experiences of trauma and pain. Confirming what psychiatrists and cognitive trauma researchers in South Korea recently reported. So about a month ago, I attended their conference, and they state that the fact that states remain in impunity and withhold apology or acknowledgement of political violence adds to and complicates trauma, making it increasingly hard to reconcile and heal. So not just for survivors, but for their families as well, notably for spouse and children of Singapore detention survivors, which leads me to Legacies of Trauma, which is in green. So survivors and their family continue to cope with physical and psychological injury, especially resulting from torture during detention. So as I mentioned and explained in the previous slide, so thinking about point number 4 as well, about how complex trauma is. So not just because they didn't receive any compensation or social support, but they also had to deal with stigmatization when they were released and restriction orders. So it was very common for about 6 to 12 restrictive conditions to be imposed on detainees when they were released. And some of these orders actually remain in effect today, like more than 30 to 50 years after their respective release. So restricting their ability to talk about what happened in detention, restricting their ability to travel, curfews, the type of jobs, and so on. So again, we start to see how these administrative penalties, similar to policing in Chapter 4, act as punishment outside official detention and after detention. So just a final note before I close, these things I have highlighted in these diamond-shaped diagrams above and below the chapters, just trying to indicate what constitutes what I would like to investigate in the future and what I think we need to investigate in terms of experiences in addition to political detention, in addition to the detention chain. So we need to contemplate deprivations in citizenship, deprivations in self, in belonging, in freedom and safety, and how this impacts a person's mental and physical health and their quality of life and their life course. So I think, again, like contemplating state powers to detain, to police, to restrict, to deport, ban, and so on and so forth, like, is crucial in Singapore state's expansive control, especially given that surveillance, police, and administrative powers continue to be expanded in Singapore's COVID-19 climate. So the understanding of detention painscape and the expensive harms that was historically inflicted on participants themselves are important for survivors, their lived experiences, their truths. So I think this would help us better understand how harmful foundations continue to inform public and social memory in Singapore today as well, and more importantly, punishment and policing rationale and objectives, as the Singapore state continues to operate and expand on inherited temporary emergency legislation 73 years on. So before I end, I just would like to pose a question to everyone, including my discussant, I guess, because I continue to write critically and think reflexively about my work as I move forward to finishing my thesis. I would like to know if anyone has any advice on how to approach writing and publishing on repressive states that continue to operate in controlling modes such as this. So I know the session is being recorded, and I'm happy to discuss these strategies after the recording ends or over a coffee break or email. Thank you.
Thank you very much, Ariel.
Here we have, an extraordinarily, powerful is the only word I can describe, but an illustration of just how widely punishment can range. Punishment is manifestly not only the sentence imposed by the court. That's fairly obvious, but those diagrams, and I love the little diamonds at the bottom, simply indicate what an incredibly long-term effect punishment has. Had Vijay been here, and I think I should say this because I don't know if you're going to have a chance to hear his paper, what was striking about his paper is it's a paper about what in India are called under trial prisoners. And believe it or not, there are strong parallels, because the under trials in India, he describes again very powerfully, are also subject to to a range of forms of indignity, which are remarkably similar to these people that you're describing being detained under the Internal Security Act and other legislation of that kind. So I think here is there's a very important and genuinely interesting link to be made here. And indeed, when I reread these papers, I couldn't help thinking back to Andrew Jefferson and Thomas Martin's paper on the first day about Myanmar, which is focused much more deeply, in a sense, on the prison experience, but nevertheless draws out these parallels. So where does this take us? Well, in the one direction which it takes us is to look at the roots of why these practices exist. And something that's been common, although challenged yesterday very interestingly, in these debates has been the colonial heritage. You can't get away from it, and we don't want to get away from it. In fact, we want to use it as an explanatory tool. And in at least those three papers, one can see a particularly British tradition. Again, there's no way of getting away from that. Not only in the security legislation, but also in the legislation governing prisons. What the British did is very interesting. The British intelligentsia of the late 19th century in some ways expressed itself through colonial legislation. So you have the Indian Penal Code, you have prison codes, you have procedural codes, which throughout throughout different regions, not only in Southeast Asia or but also in East Africa, form a particular sort of framework, which is remarkably unchanged. My own experiences in this regard, spending a lot of time in Bangladesh looking at prison reform there. One of the first things I saw when I looked at the Bangladeshi legislation was the different classes of prisoners. They were under trials, they were sentenced prisoners, and they were prisoners used to a better way of life. And this was such an extraordinary category. I said to them immediately, well, this is something simple you can change, you can abolish that. He said, Professor, you don't understand. I said, well, what don't I understand? He said, no, we have people of very different levels in society. And certainly in Bangladesh, we have people who come to prison who afterwards may end up in government, people who simply not used to be treated like, dare I say, ordinary prisoners. So we want to keep that sort of classification. The under trials, therefore, and this is the point I wanted to emphasize, and very, very vividly described in Vijay's paper, are not treated very differently from people who are subject to these restrictions. So where can I, with that little peroration, where can I come to some questions? Ariel, one thing that struck me much about your paper is you emphasize very much the colonial tradition in the Singaporean case of security legislation of one kind or another, unusual powers of detention. What I wondered was about the actual prison practices, or the actual practices of, we're not talking about prisons, the actual practices according to which people are detained. Because in some ways, I don't know Singaporean prisons, but I know something about Malaysian prisons. In Malaysia, when you go into prison, the first thing that struck me was English military 1945 or 1955, and styles and polish and so on. What would be very interesting to know is, are the practices that are used, other than the formal legislative framework, are those practices also from that tradition? Or could they be from a different tradition? Could they be influenced by CIA practices, for example? Is it specifically colonial in that sense as well? And that's something I thought you could explore. The other point that I had wanted to make in general, that you may want to emphasize, we've had very interesting developments in England, and you quoted particularly in the work of a very often quoted article by Ben Crew, which expands our notion of what the pains of imprisonment are. You go much further, and you make much more of these other pains. I wondered if you would want to say something more also about pains of imprisonment, quotes, even more broadly defined. So those are the two questions I can come to. Thank you very much.
Thank you, Professor Dirk, for your comments. So at this moment, if you have any question, you can raise your hand up using the Zoom tool. And then if you have any comments, you can also